Welcome back to the Retirement Fiduciary Podcast, a place where we have authentic, no BS discussions about retirement planning, investment strategies, and wealth management. Whether you're approaching retirement or if you've already made work optional, this show is for you. Now, here's your host, Adam Koch, President, Portfolio Manager, and Senior Financial Advisor at Libertas Wealth Management Group at libertaswealth.com.
All right, what's going on, everybody? Thank you so much for joining us today. As always, let's get started with a few housekeeping items. If this is your first time listening or watching, thank you so much for joining us. The Retirement Fiduciary Podcast is an authentic educational show aimed at providing honest, candid, fiduciary-driven insights for individuals and couples all over the country. This podcast is produced bi-weekly as we cut through all the noise in the markets, dropping no-nonsense, unbiased knowledge to help you make work optional someday, all while living the lifestyle you've always wanted. So be sure to subscribe on YouTube, Apple Podcasts, Spotify, and you can find more of what we share on TikTok, Instagram, Twitter, or they call it X these days, and YouTube. Finally, learn more about what we do and how we work with our clients, or even to schedule an intro call, just simply head over to libertaswealth.com and check us out there. Today, we are joined by Dan Barron, an expert in estate planning, elder care law, probate, and business succession, and somebody I've known for roughly 20 years at this juncture, which I'm starting to feel old the more I say things like that. But Dan helps his clients preserve their legacy and protect their assets using trusts, wills, powers of attorney, healthcare directives, and other strategic estate planning tools. And he's also the founder of the annual publication called Dollars and Cents, and he's also a published author. He's been named a Super Lawyer Rising Star for the past 5 years, a distinction given to only the top 2% of attorneys in the entire country. And most recently, in 2024, he was nominated as Best Lawyer, Ones to Watch, a national honor awarded by his peers. And I think when your fellow attorneys are giving you props, that probably really means something. And lastly, on the personal front, when he's not practicing law, Dan volunteers with the Boys and Girls Club, and he enjoys being a nomad, traveling around the country, off-roading, and soaking in nature. So Dan, thank you so much for joining me today. This is going to be fun.
Yeah, thanks for having me. Pretty sure my mother was the only one who nominated me for the Super Bowl.
Well, your mom's got some clout, apparently. All right, let's just jump right into the meat of the conversation here. What would you say are the most common misconceptions people have about probate? I know there's a lot of talk out there about avoiding it. That you should avoid it, you need to avoid it. Some people don't agree with that. How much it costs, things like that. That it's time consuming. What are the misconceptions, and what's the truth behind probate, avoiding it or not?
Hands down, the biggest mistake that people make is that they think a will avoids probate court, and it does not. If I work, I teach at local community colleges, and typically my class might be 30 to 40 people, and roughly half will always raise their hand when I ask the question, "Hey, do you think a will avoids probate?" If you think about it, if you have a bank account that's only in your name, and you pass away, and even if you name your spouse in your will, so you're married, your spouse goes to the bank and they want to take that account and put it into their name because they give the bank the will. The bank is going to say, "We're not lawyers. We're not going to interpret that will. You have to go through probate court." And I'll tell you how to avoid probate. There's 5 different ways, and we'll get to that. But I guess we should start by why we want to avoid probate in the first place. Well, it's very time consuming and it's expensive. So the average time throughout Columbus for each county in the Columbus area is around 12 months. So about a year to administer an estate through probate court. The minimum time in the entire state of Ohio is 6 months, because that is the time that a creditor has to make a claim on an estate. In terms of cost, it's actually not in my best interest to tell you how to avoid probate court through this podcast, because lawyers make more money in probate than they do creating a trust or so forth. Cost-wise, I would say at a minimum, it costs around $5,000. But attorneys actually make a percentage like a real estate agent would on selling a house. So between 5 and 10% is typically what's lost through attorney fees and court fees and so forth. So it's very time consuming and it's very expensive.
What about this whole concept of asset shrinkage? You did a webinar with us that we've already sent out a replay for those of you that want to check it out on LinkedIn, YouTube. Dan did a whole presentation on all the things we're talking about today, but a little bit more structured than this conversational podcast. But one of the most fun part of the webinar, at least for me, was where you started talking about like Elvis Presley's estate and other celebrities' estates. So this concept of asset shrinkage, during estate settlements, and why some estates can lose, 70, 80% of their value to taxes.
Yeah, it all comes down to taxes. I'm going off memory here from
No,
that.
you're fine.
But Marilyn Monroe, she lost 55% of her estate through taxes. She died with $800,000. Poor planning. Elvis Presley lost 73%. He had roughly $10 million in his estate. Poor planning. But then we get to other people who did much better, like Donna Reed. And Donna Reed, she only lost roughly 4% in her estate. And she had children from a prior marriage. She, got married again. And if you think about it, if you're just naming someone in your will, or if you're just naming someone as beneficiary on a bank account or on a retirement account, and let's say that person is your spouse in your second marriage, when that money goes to them, there's nothing preventing them from disinheriting your kids from a prior marriage. And so what Donna Reed did is she created a trust that was going to provide for her spouse in her second marriage, was always going to provide for his health, education, maintenance, and support for the rest of his life. And then when he died, he wasn't able to control Donna's assets. They would go to Donna's kids. So this way, she didn't accidentally disinherit her own kids. And then finally, Ted Knight, one of my favorite movies, Caddyshack, and he only lost 1%, died with $4 million. And instead of losing 73% compared to Elvis in taxes, he had better planning. Same situation as Donna Reed. So he, was in a second marriage, had kids from a prior marriage, had a trust, and the trust avoided probate. He was able to provide for his spouse, and he didn't disinherit his kids accidentally.
Now, a lot of people say that trusts for the sake of tax protection or tax minimization don't really matter anymore because the estate exclusion is so high now. Kind of a two-part question here. First of all, can you explain to those watching and listening what the estate exclusion is, where it's at today, and then share your opinion on where it's going in the future and why maybe that isn't necessarily the best advice in the world?
Yeah. So in terms of estate tax, or as Oprah Winfrey refers to it, a death tax, today, the exclusion is, I'm rounding, but $26 million per married couple. So that means that as a married couple, you do not pay federal tax unless you have over that $26 million. Now, you might say, well, I'm never going to reach that. That number moves. And so it used to be back in the 90s that everyone was creating these trusts because the estate tax exclusion was only, $100,000. And by creating the trust, you have an option, the surviving spouse, to move money around to save on that tax. So otherwise, they're spending 40% on tax. Today, it's not as much of a worry, but that number does jump. So, you may not have 26 million today, but by January 2026, if Congress does not act, it's going to sunset. And that means that it's going to jump back down to the old amount, which is 5.4 million per person. So roughly 12 million bucks with inflation. And it's definitely going to go down, especially in not getting political. It doesn't matter, which side you vote for, but it tends to seem that one party wants to stick it to the other. And I think either that it's going to sunset or they're going to amend it to go down even further. I think they're going to push for it to go down even further. Word around town, 70% chance. We think that Congress is going to pass something. And so now taxes might be a bigger issue for people to, want to create a trust. But at the present time, most people create a trust to protect assets for their kids, to avoid probate court, avoid scams, creditors, and so forth.
Okay. Now, what do you say? You mentioned trust again. So we're going to talk a little bit more about that and a couple different kinds of trusts, actually. But one of the big questions I hear a lot in the financial planning world, and we do advise on this, but we don't obviously do what you do for a living. We don't write wills, trusts, powers of attorney, things of that nature. What are the advantages of setting up a family trust versus just relying on a will, beneficiary designations, TODs, things like that? In other words, who needs a trust and who doesn't?
Yeah, it depends on everyone's circumstances. Not everyone needs trust. But the way I look at it is it's like an insurance policy. You don't know what situation your kids are going to be in down the road. And, we pay every year for our homeowners insurance. In the very unlikely event, less than 2% chance that a fire or tornado, some type of natural disaster is going to happen, and you pay every year for your homeowners insurance. Unless you live in Florida, then it's a little more likely with a hurricane. But very unlikely event that something's going to happen. So a trust is like an insurance policy that, in case your children are getting divorced, or if they have creditor issues, if you know that they have spending problems, and you certainly don't want them getting that money outright. So it takes a snapshot in time. Whereas if you were just naming them as beneficiary on an account or naming them outright in your will, well, you can't turn that off. So a trust gives you control even after you're gone, to protect the assets for your children. It's their option. I think the most common thing that we see is, the best thing that we want as a parent accomplishment is that our children are self-sufficient and they are not reliant on an inheritance from us. And so when you pass, you have this inheritance coming and they don't need it. So if they keep it in trust, it's forever protected. But the moment that they put it in their joint bank account or in their personal account, well, now it's subject to the will. And it's their option. They can pass it on to their kids, i.e. your grandkids. And so that's the benefit of having a trust. Today, it's not so much taxes, but it could be.
It could be, right. Especially depending on how things come the next, 5 years or so. I always tell people when I started my career, which I'm really going to date myself again here, but when I started my career 10 days before the World Trade Center went down, the exclusion at the time was $1 million. So in other words, even if you had a trust, if you added up all your assets, liquid assets, investment assets, bank assets, your cars, your house, everything in your life, and you had more than $2 million when you passed away, then you were going to get taxed up to, I believe it was 48%. And that's after you already paid income tax and potentially capital gains tax as well. You're getting taxed again and losing almost half your money again. Yep. So now that we're up to such a huge number, 26 million, and we also have by far the highest amount of government debt in this country that we've ever had in history, I would not be surprised at all to see things change a little bit. Maybe not 1 million. I don't think it's going to go down to 1 million, but I wouldn't be surprised to see the government use that, rolling back those laws to something more, I hate to use the word reasonable, but something more reasonable, to help pay for all this debt. But I have a hard time believing it's just going to keep going up, exponentially like it's been going.
Yeah, I mean, I don't know if you recall the PPP program that they, both sides ran, that program when Trump was in office, and then Biden, and then there was a second wave, and the amount of debt that created was incredible.
So a lot of debt, and there's been nothing but spending since pretty much 2000. So I'm not picking on political parties here, maybe, and this is a terrible time to do that. That's the last thing I want to do. But it's everybody's spending too much. The bottom line is we're talking about estate planning and trusts here. How do we minimize our tax burden and make sure our money stays in our family? So sticking kind of on the fringe of trust talk here, and I'm going to come back to trust in a second. But in your experience, what would you say is the biggest mistake that people make when it comes to planning for long-term care expenses? So that could be not assisted living necessarily, but skilled nursing care, assisted living, and even memory care, which is insanely expensive. And how could they better financially prepare for it, whether that's using insurance, estate planning strategies, or both?
Yeah, I think number one is people don't understand how expensive it is. And that's number one. And nationwide, the average cost per month is $9,513 per month. So that's roughly $114,000 a year for a nursing home, being the highest level of care. The average person stays in a nursing home for 3.2 years. So that's $365,000 and change. That's a lot of money. So number one is not understanding how much it costs. Secondly is very simply not preparing. Long-term care insurance is an option, and you could talk more in detail than I can about that. And there's many different types of policies out there. But you can't wait. You can't wait until you're 80 years old and then you want to get a long-term care policy. It's not going to work. And
cost prohibitive.
No, I mean, one size does not fit all. There's, and I'm sure you have another podcast on this, but there's traditional plans, there's hybrid plans, and it all just depends on your circumstances. There are ways to protect assets for through a trust, but it's irrevocable. It's different than what we talked about with a family trust. But hands down, number one is people don't understand how much it costs. There's also a common misconception of that. Well, I don't want the government taking my money. It's actually the reverse. When you go to a nursing home, they're private companies, so you're paying out of pocket. The first 100 days, Medicare will pay for you, but then after 100 days, you are paying out of pocket. And when you run out of all of your assets, then you're going to ask for help, and that help is known as Medicaid. And there's a common misconception of how that works.
Huge difference.
Yeah. I mean, bottom line is it's expensive, and it is coming out of your own pocket to pay for, the way I look at it is if you go to a hotel, it's $200-300 a night. If you go to a nursing home, it's $200-300 a night, but then you're also paying for services that are also needed. Well, so it's more, it's $400-500 a night.
Yeah. I just looked up the stats just because I was curious, because I used to have these memorized years ago, but this is fun. So, well, it's not fun at all, but it's interesting. How's that? Probably bad choice of word there. But the national average for 2024 for a semi-private room, you don't even get to be by yourself, is $8,500 a month.
Yep.
To have your own room, you're going to pay $9,300 a month on average. The most expensive state, hold on, let me hold this one for last. The cheapest state in the union for semi-private room is $5,200 a month and $6,000 a month for private. Texas, kind of surprised me.
That's interesting.
The most expensive one, and I already knew this was the most expensive, but the most expensive state in the union to get long-term care costs or long-term care period is Alaska. And get this, $31,000 a month. Now, I don't know why anybody would want to retire and get nursing care in Alaska to begin with. No offense, Alaska, but I just found that really interesting.
Wow.
So when it comes to nursing costs, obviously we've just talked about how insanely high they are. When at what point does an asset protection trust come into play, and explain to our viewers and listeners what that even is?
Mm-hmm. So first of all, let's back up to explain what a trust is in general. It's very similar to a will. A trust is a document. A will is a document. A trust tells the world who's going to be a beneficiary. So does a will. A trust puts someone in charge. So does a will. A trust avoids probate. A will does not. And there's two different kinds of trusts. There's revocable and irrevocable. And you could actually have both. You could have more than one trust. The asset protection trust is something that we would bring up to clients. And I don't like to put an age on it, but typically if they're 65 or older. And its purpose is to shield some of their assets, not all, from the nursing home. And essentially what we do is we take some of their assets, typically their home, and take it out of their name and you put it into this trust. So this way, if they find themselves in a spend down where they are spending $9,000 or $10,000 a month, once they spend through their assets, well, what does the nursing home go after? They go after your house. That house is not in your name, then they can't take it. They can't probably not. Now, the important thing to remember is something called a 5-year look back, meaning that the house has to be in the trust for 5 years before it's protected. And it's not an all or nothing, because if you have $360,000 in the bank, and then you have a $400,000 house, and you create the trust today, and you go into a nursing home 2 years from now, well, you still have $365,000, i.e. $10,000 a month to make it to that 5 years. So everyone's circumstance is different. But the whole concept is that you're putting assets into this trust, taking them out of your name. And if you do go to a nursing home, they're protected. It depends on what your net worth is, because I feel that some people are self-insured. And, if you have $2 million or more, I don't think you need an asset protection trust. If you have $1 million or more, now you're maybe a gray area. It depends if you're married or not. Because you do not take retirement assets and put them into these trusts, because if a retirement asset is in RMD status, the principal is already protected. The income would go to the nursing home, but the principal would not, which is another reason why the house is kind of a no-brainer, but the other assets takes a little more of an analysis. If it's not a retirement account and you just have a standard investment account, if you are living off of that asset, need it to buy groceries and entertainment, vacations, then you're not going to put that in an irrevocable trust. But if you have money that's sitting there, and if you're not able to get long-term care insurance and you don't plan on using it, then perhaps a chunk of that you can put in the trust and save it for your kids.
Just so everybody understands, when Dan said irrevocable trust, that's the same as an asset protection trust. It's just another name for it. I just think that saying irrevocable or irrevocable, depending on what part of the country you live in, right? Depends. I think that asset protection trust just makes a whole lot more sense. But anyway, sorry, I digress.
No, that's a really good point. And attorneys like to use a lot of buzzwords, unfortunately.
I think everybody does.
Yeah.
That's the problem. Part of the problem.
Yeah. But no, the asset protection trust. And, in terms of the house, one question that people often ask is, well, why can't I just put my home in my son's name? Why do I need this asset protection trust?
I already knew what you were going to say, and I'm already shaking my head.
Huge mistake. Number one, if your child gets divorced, the house that you're living in now belongs to their spouse, or at least a portion of it. God forbid if your child passes away, then the house that you're living in belongs to their estate, which would be their spouse. But also you lose that step up in basis when they go to sell it. So they will inherit the house through this asset protection trust with step up in basis, meaning there is no tax. If you purchased it for $100,000 and it's worth $300,000 upon your death, your children are not going to pay a tax on that $200,000 gain. Outside of the trust, if you just deeded it to your son and you're living there for however many years and then it appreciates in value, and then when they sell it, well, now there's tax. There's also, if you're just quit claiming it to them, there could be a transfer tax as well as a gift tax. Probably the gift tax is more of a glass ceiling, but you'd have to file a tax return. So it's just not the way to go. The asset protection trust is definitely the way to go to shield against nursing home costs if you're 65 or older and depending on your assets.
Help us, if you can, and this might take you a second to think of one, because this just so everybody knows, Dan did not see any of these questions in advance, so this is all on the spot here. If you could share a story that you have about an actual client situation that you think really kind of encompasses how trust planning can help someone, and if you want to split it up into two parts, you can, or just make it one story. I'm just curious if you could tell us a real life story of a situation where a trust helps somebody out, whether that be on the back end or the front end for that matter.
Yeah,
might be two different trusts.
There's actually a case that I have right now. It's one of the most heartbreaking cases that I've had in all my career. Top 10, it just happened last week. And this situation is not a situation where a trust helped. It's the reverse, where a trust was needed. And boyfriend, girlfriend, life partners, they've been together 15 years. They have children from together, but they never got married. House is in husband's name. Okay. They have a couple $1 million. He has a couple $1 million on his side of net worth. She is the caretaker at home, taking care of the kids. They have a 3 and a 6-year-old child. He died about a month and a half ago of a pulmonary embolism.
Oh, wow.
Total sporadic. And what he did is he had life insurance, quite a bit of it, but he named his children instead of his significant other as the beneficiary. Well, a 3-year-old cannot inherit. The house is only in his name. His girlfriend, the mother of his children, cannot inherit. So, and in talking to the family, it was his intent that he wanted to leave everything to his wife. Okay. And what he could have done is he could have set up a trust and he could have left everything to her. And maybe if he was concerned, they're young. So if he was concerned about her remarrying or something like that, he could have appointed someone else in charge to manage these funds after his death instead of his girlfriend. She could have, lived up that for the rest of her life, and he could have provided for his kids as well. But he had no plan. And even with a will, he could have, set that up, and it would have gone through probate. But now, for the next probably 2 years, the children are going to be appointed a stranger to manage those funds, and mother, being the biological parent, is going to have to go to this person to ask for money for the next 18 years until they're 18. So that would be a really good reason for having a trust. I've been in other situations that it's I love when I talk to clients and the trust worked for them, or it worked for their parents. And so I often see cases where, you did a trust for my parents, or, someone else did it. And, it was really easy. We didn't have to go to probate court. And in some cases, my mom went to a nursing home and, they took everything, but they didn't get the house. And so we were able to pass that down. So I see that often, as well. But I think the horror stories stick with me more than the stories of where things work out, because you just think of, gosh, if they only would have done this, this whole thing could have been.
I think it's the same thing with people's money in the market. I think that psychologically, behavioral psychological studies have been proven have proven that the pain of loss is much stronger than the joy of winning, or the joy of making money or success. So I think that's probably why it's easy to remember those bad times, but that's awful.
Yeah. I could talk for hours with stories.
Oh, I'm sure you could you could write another book about it, right? But yeah, you kind of answered my next question, actually, inadvertently, but maybe just kind of break down the details of how you approach complex family situations, which we run into here at our office all the time. Second marriages, blended families. So when you're designing an estate plan that ensures fairness and minimizes disputes that may occur in the future, what kinds of things are you looking to do?
Right. So, I mean, the first thing is you have to realize that not everyone's situation is the same. They can be very complex. The most common thing I hear from, let's say, someone who's single is, "Oh, my situation's easy. I'm single, no kids, not married." Well, actually, your situation is a lot more difficult, because if you were married, that is who's getting your assets, right? So, the first thing is asking the right questions. We, meet with every client, and we have a questionnaire. We go through it in detail. And, that's something that LegalZoom's not going to offer. When you're going to LegalZoom, right, pretty much you have a preconceived notion of what you need going into it. They might ask you questions, but they're not asking you all the questions of, complex situations or trying to protect assets. So, it's having that discussion. And as the attorney, I have an ethical responsibility, especially for married couples, that they have a joint plan, a unified plan. And if they're disinheriting one another, then I can only represent, one person, and the other person has to, in all fairness, to, get another attorney. I've only been put in the situation once where I met with a couple, and I later on get a phone call, and it's like, yeah, and I really don't want to leave him, what we said in the meeting. And I, had a decision to make there, but to try to be fair to everyone, it's having those meetings, it's getting everyone on the same page, it's asking the right questions, it's proposing not just one plan, but sometimes you have to really guide people to pick different options, because you can't read their minds, so you give them different options, and just to get everyone on the same playing field and create a unified plan for everyone.
Yeah, it's like good, better, best, right? I love that, because I always joke that if my job was easy, I wouldn't have a job, because, people can do this stuff on their own. I don't know that they're going to do the best job. And I always say that in order to do any of this stuff on your own, you have to have two things. First of all, you have to have the interest, and then the subject matter. And then second of all, you have to have the time. And what we find most of the time is people don't have the interest, so they do a poor job inadvertently, or they have the interest, but they don't have the time. And because they're busy being a mom, dad, husband, parent, they're too busy. Work, the life is busy. So I just see all the time where people don't update their estate plan after a second marriage. I've got stories, as I'm sure you do, where somebody's in a hospital in North Carolina and they are unconscious, and the POA, the medical POA, is the ex who's in Ohio.
Yep.
And then no decisions could be made by the new spouse, because of course the POA is the ex spouse. So it's so important, I think, to update these things, stay on top of them. Which leads me to my next question. Why, if I haven't already given it away, the punchline here, why is it so important to have an estate plan, And then B, to regularly update it, and how often is regular, I guess, and what types of life changes should prompt someone to review their plan. And by the way, 52% of people don't have an estate plan. And I don't know what the statistic is for how many of them are outdated, but I believe more than 70% that have an estate plan don't even know where the documents are. So I'll shut up and let you answer.
Yeah, well, for those 52% who don't have a plan, the state of Ohio or whatever state you live in has a plan for you, and that is why you should have a plan. You know, most people don't memorize what the statute is. They probably don't even know that there was a statute. And if you have no plan at all, that's what it's going to go by. It depends if you're married, if you have kids, if your relatives are still alive. And, you have the choice of determining who is going to be your beneficiaries, who will be in charge, and who will make decisions for you if you are incapacitated. And if you don't make that choice, then the state is going to make those decisions for you, and it will be very costly and time consuming. Whereas it's very simple to set something up, and it will not be nearly as costly or time consuming. So that is why we plan, of course. None of us want to think about our demise. I often have clients who, say, I have been dreading coming to see you because in seeing you, I know I'm going to die. It's like, well, I promise you one thing. Yeah, we're all going to die, but it doesn't mean that you're going to die, this week or this month. And, I've probably met with 2,000 people over the last however many years. And only twice within a 6-month period of when someone came to see me did they, pass away. So you see your estate planning attorney, it doesn't mean that you pass away.
So superstition is real, I suppose, but yeah.
For sure. Yeah. So that's why we should plan. And without it, you're just leaving it up to the state.
So one of my favorite strategies, if I shoot to the other end of the spectrum here, we talked about long-term care, we've talked about running out of money. We didn't get into emergency situations, which maybe we should do on another podcast and focus more on the elder care law side of the fence, because I think that would be great for just one episode alone. There's so much to unpack there. But one of my favorite strategies when it comes to estate planning on the other side of the fence is, especially as the stock market's been doing well this last couple of years, people are making more money in the market. They're concerned about taxes going up, and they're becoming, I think, overall maybe more charitably inclined. So, those who are philanthropic, charitable planning, the inclusion of trusts with strategies paired with charities. One of my favorite strategies is taking a strategy where you take a lump sum of money. It doesn't have to be all your money, obviously, it probably wouldn't be, but a lump sum of money, you put it into a charitable trust. You get a tax deduction up front. So because the charity doesn't pay taxes, you get tax-free income while you're alive from that trust. And then when you pass away, second spouse passes away, the money then goes to the charities you chose, essentially creating a win-win. Tax deductions today, tax-free income while you're alive, and then a win-win for you and the charity. I don't mean to give away the whole punchline here, but can you talk a little bit about maybe making that a little bit, maybe, I don't know, expanding on that a little bit and how cool those strategies are?
Yeah, there's several different ways you could set up. It's, again, it's called a charitable remainder trust. Sometimes you can set it up, as you pointed out, where you give a lump sum and you get payments over time. Or it could be the reverse, that the charity gets payments over time. And this way that you have an opportunity to see, that charity benefit from it. The tax benefits, talk to you or CPA, it's typically not one for one. If you give, $300,000, which is the minimum for a CRUT, charitable remainder unified unit trust, it's not, you're going to get $300,000 of a benefit right away. And you could also stretch those payments out, if you're getting that payment from the lump sum, 10, 15, 20 years, just whatever makes sense for the tax benefit, that you're getting. But it is a great way, especially where, not just from the tax side of things, but, if you want to leave something, let's say to the APL, and you leave it in your will, or you name him as a beneficiary somewhere, and, then you pass away. Well, yeah, the money will get there, but you don't really get to enjoy it. And I think that's, a benefit of donating while you're alive, so that you can enjoy seeing that charity and looking at what you donated go to good use. So
Yeah, you took the words out of my mouth. I was going to say, I actually encourage a lot of clients to give more money away to their kids now, as opposed to waiting till they're gone, so they can watch them enjoy it. Do family trips, pay for a house on the Gulf Coast, and everybody just has to get themselves there to have a nice week-long family vacation where everybody gets to hang out, play cards, sit on the beach, whatever. But when it comes to estate planning, charitable planning, I think that's awesome too. And then the other thing I just wanted to chime in on is a common misconception when we talk to our clients about charitable planning is that, well, I really want to do this and all that makes sense. The tax benefits are nice, but I would really also want for my kids to get all that money. And what you can do, first and foremost, is buy life insurance. Even though we don't sell life insurance at our office, you can buy life insurance to replace what you've given to the charity. And after tax deductions and tax savings, you're still going to be ahead in the game. And then, second of all, going back to our discussion on death taxes, if the exclusion gets lower and if it becomes a problem, you can actually set up something called an irrevocable life insurance trust, or ILIT for short, to make that life insurance outside your state, so you don't have to worry about making that number part of the equation that the government's going to tax you on. So that's another kind of a cool piece of the pie here. We're starting to run out of time, so I just have one question left for you. And what would be, and I know the answer to this question, but I want people to hear it from you. What would you think? Because I know there's tons of people out there now that, whether they just watch this whole thing or they're just hitting play toward the end or they're skipping through it, what do you think is a reasonable fee, or the average fee out there, to pay for a basic will, power of attorney, and healthcare directive versus the trust planning side? And just lay it out there, because I think that people don't realize what it costs, what's reasonable and what's not. And I think there's a lot of bad information out there.
yeah, it's going to vary, on the circumstances and the work. For us, we don't charge by the hour, and we try and determine the amount of labor, involved. But, first of all, what is a basic plan? So that's having a will, your financial power of attorney, healthcare power of attorney, living will, HIPAA, maybe some transfer on debts in there for automobiles or your car, or your house. And I mean, you could expect to pay somewhere between $1,500 and $2,500, depending if you're single or married, to have your basics in place. And you might say, wow, $2,500. Well, if you have a $500,000 in assets, including your home, you're going to lose $25,000 in probate, right? So, like on the low end, as you move along, and so a basic plan, someone who's in their 20s or 30s, no kids, and they just need someone to make decisions for them, tell the world where their assets are going. That's a basic plan. When we start having children, when we get married, now we're talking about a trust. And, regardless of age, but if those are your circumstances, you still need your basics. And at least for us, a client spending somewhere around 4, 5, maybe 6,000 to get the trust, but then it also includes, all your basics. If you work with a big law firm downtown, you probably spend 10. And as you move along further and you're 65 and you've got this trust already, but you want to add the long-term care or the asset protection trust, that would be an add-on. And it really depends if you already have things in place of what that would cost also. But generally speaking, if my client, if I meet someone for the first time and they've got 2 or 3 kids and they're their first marriage, and maybe not even, and it might be a second marriage, and they need to get a trust established and they need to get their basics established, or they need to get them updated. You're right around the 5-ish mark, but it depends. If I have a client who has tax considerations, it's going to be much higher. Sure. Because we're doing different type of planning for that person versus your average client, if you would, getting a basic plan and a revocable family trust in place.
So what I would add is that there is no shortage of stories that Dan could tell us. We could do hours of podcasting on stories of how poor, improper, or absent estate planning has cost people tons and tons of money, well above and beyond the cost of, a $5,000 trust, let's just say. Or you start getting into tax considerations, you start getting into long-term care costs, elder care law, and the numbers just get it's a hockey stick. I mean, it starts to get really, really expensive. So I think that, you got to be really careful in this world when you're wanting to do this on your own. Can you do it on your own? Yeah, I'd be really, really careful. LegalZoom, you can do it on your own. Like I said, you have to have those two things, the interest and the time. But even then, I mean, how much is it worth to you? You have to start asking yourself, do I want to wing this, or do I want to shop around for the cheapest price? And am I going to be properly, prepared for my future and perhaps one of my biggest expenses I've ever had, or my family will have when I'm gone? So with that being said, I think that you probably need to avoid deals whenever shopping for parachutes, brain surgery, fire extinguishers, and financial planning and estate planning advice.
I like the parachute example. I always refer it to, WebMD, or,
right.
If I have a situation and I go on WebMD, every time I go on there, it looks like I'm dying of cancer. But if I go to my doctor, that's the thing. I've had 2 back surgeries. And I'll tell you what, for each one, I didn't ask who was the cheapest. Who was the best person who's going to do my back surgery. And I didn't care of the cost. To me, estate planning and making sure that your family's not sniffered and that they're taken care of is the same. So
it's up there, and it's like stepping on a landmine. Once you step on that landmine, you're going to wish you would have prepared. Yeah. So with that all being said, that's our time for today. Best way to get a hold of Dan, if you'd like to get a hold of him, would be on LinkedIn first and foremost. Just look him up on LinkedIn, connect with him there. You can also reach out to him at either dan@baronlawcolumbus.com or dan@baronlawcleveland.com. He has multiple offices in both Columbus and Cleveland. You can also find other links and contacts info in the show notes below. But as always, I always say there's thousands and thousands of podcasts out there these days, and you chose to give ours a listen today. So thank you so much for tuning in, and we'll see you next time.
We hope you enjoyed today's episode. If you like a second opinion on your retirement plan or investment strategy, please head over to libertaswealth.com. This podcast is for informational purposes only and should not be considered as legal, financial, tax, or as a basis for investment decisions. Always consult a certified financial planner or a fee-only fiduciary advisor before acting on any ideas discussed.